Michael Bryant, the most important thing in trying a case is picking a jury who's going to listen to you. So what are we doing for our Fashion Friday show?
Yeah, I don't know. Maybe dressing for the jury is important too. Some say you win or lose the case with jury selection. So I think with the Kelsey Fitzsimmons trial looming, we should explore.
Justice, where are you? Michael and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down me, I lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
Hey, you brought this up, so let me tell you a story.
Okay.
Fashion and juries, right?
Right.
So I do a month-long trial against. I was defending a pharmacist, okay, and it was a case in which we admitted liability. It was kind of like It's a Wonderful Life. He put the wrong pills in the bottle, you know. So we were not contesting that was our problem, liability. The question was damages. 4 weeks on this thing with damages. Comes out, fine. We knew we were going to get hit for something. So we thought we minimized the damage. Good thing we went to trial. Talking to the jury members after the fact, asking about, each party, the attorneys, how they were reacting. One thing they couldn't get past was the plaintiff attorney's white belt that he wore in court for 4 weeks. And it was not in the summer, if that matters. I don't know. I'm not a fashionista. I don't know, but that maybe would make it more acceptable. So anyway, fashion is important.
Fashion is very important. So let me tell you, since it is Fashion Friday, and I play poker, okay? As a matter of fact, I played it earlier today at Resorts World Casino. All right. Let me just tell you that we can mesh those two. All right. Now, I don't know if it meshes with crime, but I want to bring in this. Okay. This. All right. I'm going to add it to the stage if I can. There we go. This is, and let's see if we can play it now. That would be nice. All right.
Nice.
And wouldn't that be novel if we could play it? I wonder what's happening here that we can't play it. Well, this is an Instagram post. All right. You see, we may not be able to play, which I don't understand why I can't, since I'm sharing my screen. But this is, if we go back, and I may have to take a screenshot of this. All right. Let me go back here. Let me see.
There we go.
There we go. Okay. There we go.
It's one of the Jenners.
It's one of the Jenners, and we're going to apparently have to. I don't know why now we don't have audio.
Do we really need to hear her?
No. But what we do, I just want you to watch because you can read it.
Is this halfway getting dressed? What is she doing?
This is like the Corey Richards trial when they put the things on the screen, and what's happening is you're really not seeing. You don't get to read the text and all, but you get to show what's on the screen by what's written under it. And so this is Kylie Jenner. She is giving poker lessons now on her Instagram account. Now, I just want to point out the fashion to you. She is wearing what they call, and you can get educated, a bullet bra. All right. That is a bra. It's actually made by Dolce & Gabbana, and it's shaped like two bullets. It was in the runway show, I think, last year. It was one of the things in the runway show about a year ago for winter. And that's what she's giving lessons in. She's telling people which cards we beat what. She's talking about having a game and what makes a good game, good music. So I just want to let you know that I may have competition in the future in my poker games, but I can guarantee you that I'm probably not going to be addressed like this. But go take a look at her Instagram page. It's actually Vanity Fair is publishing it. You'll see the Vanity Fair page. And yes, this is Kylie Jenner. She gives poker lessons, and she's talking about what makes a good poker game. So I have merged poker with Fashion Friday with us.
I'm sorry. Did you say something? I was busy paying attention to my poker lesson. Okay, so
I know that's exactly the point.
Yeah, and I think I learned absolutely nothing about poker. Anyway, okay. So speaking of juries, I guess we'll find out if fashion becomes an issue in the Kelsey Fitzsimmons case more obviously. Both sides have now presented what they hope the court will allow them to question the prospective jurors about, the voir dire questions. Every jurisdiction does it differently. Federal does it differently than state. I think you would agree federal is much more restrictive on what the attorneys are allowed to do, right?
You have three, just so everyone knows, you get three people that can get knocked up. That's it. All right. That's it. And sometimes in the states you can get 7, 10, 12, depending on what the jurisdiction allows.
Yep. And it depends on how long the trial is going to be, the nature of the trial, all of these factors that the court will then decide, okay, we need 2 alternates and you can have 4 challenges, or whatever the mathematical equation is. It's supposed to be specific as to the case and the length of the case and the complexity of the case. Well, with Kelsey Fitzsimmons, I know they're saying 3 days, including jury selection. That might be a little aggressive, maybe optimistic. I'd be shocked if they get more than 1 alternate, but I don't know. We'll find out. But each side has submitted their proposed questions and hope that the judge will allow them to ask specifically these questions of prospective jurors, where there will be general questioning anyway.
And because it's a criminal trial, 12 people have to be in the box. It has to be unanimous verdict, even though the trial may be short. And then the 4th person gets chosen by the judge. Now, many judges just go with who's number 1 in the box, and other judges choose the 4th person.
Judge Bev Canoni, she goes with number 1. Whoever is number 1 is it. And is it? They don't use the drum, do they? But Ohio uses the drum. Massachusetts.
No, they don't use the drum because the court gets to decide who is the well, that's for the alternates. I don't know. It's different, but in terms of the selection, the judge gets a selection. She can choose number 1. She can choose number 10. We argued in Hernandez that was a discriminatory process because if you have 8, 9, 10 people who are minorities on the jury, and the judge gets to choose, and he chooses the white person, that's kind of doesn't give anybody else a chance, does it?
Yeah. I mean, it certainly opens the case up to some sort of prejudice or bias. Interestingly, I'm thinking of the Karen Reed number 2, African American gentleman.
Number 1 in the box, and she chose him, and that was probably a strategic move on her part, so she couldn't be challenged for being discriminatory.
Maybe it's reverse discrimination. Anyway, so here we go. Let's start with the Commonwealth. This is the Commonwealth versus Kelsey Fitzsimmons. Commonwealth's request for jury questions. Now comes the Commonwealth and requests the following questions be posed to the jury in addition to the standard jury questionnaire and the statutory questions. So here's what they think is important. Do you think that the testimony of a police officer is more believable than other witnesses? And I would hope the defense wants to have that question answered as well, right? Mm-hmm. Do you think that the testimony of a police officer is less believable than other witnesses? So they've done something here. When you ask yes and no questions, you're putting yourself in a bind. I don't know I'm assuming these are going to be asked orally. Therefore, there should be some give and take. But if they're in writing, the person's not going to write out a narrative if you ask an open-ended question. But the question should be open-ended. It shouldn't be, do you think the testimony of a police officer is more believable than other witnesses? Because that's a yes or no.
Right.
It should be, why do you think police officers may or may not be more believable as witnesses? And then they can, I think they should be more believable because they take an oath. Or I don't think they should be believable because I have heard so many stories about officers doing not legal things, or whatever it may be. Yes and no doesn't really help you really a heck of a lot. So they're trying to fix that by doing two questions to get to either answer, but it's still going to be yes or no either way. I don't like it. Do you know anything about the case from any source other than what you've been told today in the courtroom or in this questionnaire? Oh, so it's going to be a questionnaire. It's going to be a yes or no. That's unfortunate. But
hopefully there's a follow-up. Like, what did you hear? What did you know? And hopefully it's not in front of other people, right? I mean, that's the mistake judges make. They ask a question, they ask, well, what do you know? And then the whole jury panel gets infected.
Of course. And I think in Bradel's series of questions, he makes it very clear that he wants to have a one-on-one with these folks. Obviously, you start with the whole herd, And then you go through very obvious excuses. People can't be there for whatever. I'm a sole proprietor of a business. I have to close the doors if I'm here. Okay, you're excused. All of those things. I have prepaid vacation plans. Here's my ticket.
I have surgery.
I got
tomorrow.
surgery. Okay, bye. But weed those folks out. And then as it starts to get narrowed, the court will ask very specific questions. And then that narrows it even more. And then the attorneys will get into what really should be the hardcore potential jurors. And that's where these questions will go. Now, you're right. I hope if they're just giving these folks a questionnaire, that once the attorneys get to look at the answers, they can say, prospective juror number 203, you said you don't think police officers can be trusted. Why is that? I have no problem with that. So if that's the way they're going, great. It's just to me, it's another layer, and it makes it more time consuming. But it's their process.
When you're trying to do justice, you want to make sure you have a jury, and we all say we want juries that are non-biased, but of course, really,
no, you want juries that are biased, but in your favor.
Juries that are biased in your favor. That's what you're looking for. You're looking for a biased jury in your favor, or you're looking for a juror who will listen to you, who isn't biased and will listen to your case. If you don't pick that jury, you can forget it.
Yeah, and I always like to split them into alphas or wolves and sheep. And their personalities are very clear. Very seldom do I see somebody and I'm like, wow, I'm not quite sure if this person's an alpha male wolf or female or kind of a follower, a sheep. It's always, to me, pretty clear.
And you want the alpha to be on your side. You want the alpha to be leaning to your side, that the sheep will follow. That somebody just won't argue, with them. Oh yeah, okay, that's fine. I agree with that. But if you have your juror who you think is a sheep, you got to be careful, because then you don't want an alpha who's built towards the other side or leaning towards the other side.
Yep. Let's see. Have you read, heard, or seen anything about this case on the internet, social media, posts, newspaper, magazine, radio, TV, or anywhere else? Obviously, these days, a much more important question than it used to be. And one of the, I know that Tim Bradle asked for sequestration, but didn't ask to have them sequestered from social media, etc. So
that's
and that relates to the witnesses, of course. I'm assuming the court will add that little addendum there. Who was the judge that was so adamant about it? Was it the Walsh judge? I think it might have been the judge in Brian Walsh, where
Judge Fernair.
She was adamant about the whole social media, no texting, no emailing, I think not just don't look at it, but don't even engage.
She was great, though. She was great. I was thinking about her because I was watching Judge Mrazek this week in the Corey Richards case, and he is so good. And we've seen such terrible judges, and then again, we've seen such great judges who just rise to the occasion. And when you see them, you say, this person should be on that Supreme Court for that state. They're just so darn good.
Yeah. Yep. I'd much rather see that than be sitting here criticizing the judge. We can criticize somebody, but I'd rather the judge be somebody you're saying this is the way it should be done. The dog's going crazy because I won't let him out. And look at I can't. My arm's not long enough. I can't reach the door. Sorry.
Can't reach the door. Tubi just came in for an hour and a half, so he's pooped a pop. He also had to go to the vet because Tubi has to have his teeth cleaned next Tuesday. He's going to go into anesthesia when I am in federal court. Of course, my heart palpitation when I'm not here. But he's going for his first teeth cleaning. He's almost 5 years old, and when the vet said, well, your dog has to undergo x-rays because he's almost a senior. And I'm like, Tubi's not a senior. Tubi's not a senior.
Even in dog years, isn't that 35?
I know, but I guess the vets think at 5 years old, and he's not quite 5 yet, but they think at 5 years old, that's when you should be a little bit more careful for anesthesia. I mean, for us adults, no problem. Just go.
Yeah, go ahead.
Get your EKG. You're fine. Let's go.
And Domino's not quite 4. But I have to have a little anesthesia for a little thing I'm doing. But
you'll get some good sleep.
They didn't seem to be too concerned about it. So
I know. But for dogs, I guess they it's different. I mean, you better have somebody. For people, it's like, okay. But you're gonna be fine. I mean, we're gonna talk to you on next week sometime, and after we talk to you over the weekend, you're gonna be like, oh, that was the best sleep I've ever gotten.
Yeah, I'm looking forward to it. Okay, so Where are we? Oh, have you formed number 5? Have you formed or expressed any opinion about this case? Okay, pretty straightforward. And again, a yes or a no will clearly be followed up. Has anyone expressed any opinion to you about the defendant's guilt or innocence? Okay. Do you know of any bias or preference that you may have in this case against or in favor of the Commonwealth or the defendant? These are all just textbook rubber stamp. There's no insight into what the Commonwealth is thinking. These are very standard
questions.
Boring questions.
They were code copied from another jury question.
Oh, yeah, it is a cut and paste special. Have you or someone close to you ever suffered from a mental health disorder? Okay, that's getting a little more on point. Have you or someone you know ever suffered from postpartum depression? Clearly on point. Is postpartum depression a diagnosis
maybe,
with which you are familiar?
Yeah, I was going to say, maybe they should ask whether they know what postpartum depression is.
Yeah, maybe you should put those in.
Yeah, reverse order.
Those.
Right.
Yeah. Let's see. Do you have any training or experience regarding mental health? That'd be good. You find out some mental health professionals on the jury. Have you received any special training in the use of firearms? Okay, and again,
how about if you do you own a gun? How about if you own a firearm?
Yeah, is that on here anywhere? Nope, I don't see.
No, I didn't see it.
So maybe they're saying, yeah, that is weird to go.
Because you got to ask, because you may not have special training. You may own
objection. Can you object to the voir dire question for lack of foundation? Because
you can ask the judge to put it in. Yeah,
they need some foundational question. Right. Anyway, let's put in 11B, and that would be: do you own a firearm? And then 12 is: have you received any? Yes, have you received any special training in the use of firearms? Do you have any knowledge regarding how a specific firearm works? Have you or someone close to you been involved in a situation involving a firearm or been a victim of gun violence? That's all very important stuff, I think.
Right, I agree.
I expect there to be some 15.
Some?
I expect there to be some publicity regarding this case on television, in print, and on social media. Would that affect your ability to be fair and impartial?
How about on streaming channels like Justice Serves TV?
Well, I guess that we're in the social media grouping,
aspect, right? Yeah.
Yeah.
And technically not, though. Technically, interestingly, not. It's not really,
no,
YouTube
it's not.
It's social media. It's a streaming network. It's a streaming channel.
It is, and that that's the new wave. And obviously, this is old-timey type questions where they put up their television, print, like back in the day, that would cover it. You might even throw in radio if it were something special enough to have it, like the Nuremberg trials on radio.
Well, they should put it on radio anyhow, because you have people driving in their car with Sirius radio, Sirius XM all the time.
So this brings me to an interesting question with I don't know if I'll call it the demise or the changeover of Court TV, Law and Crime.
Which happened this week, right?
Which happened this week. It's kind of bizarre. I've mixed emotions. I knew it was coming, but having worked there, having worked at Law and Crime, and knowing where it's going, it's unfortunate. Hey, it's the nature of the business. So what happens then? Because I've seen nobody in those categories, and I'll call them streaming / traditional.
Right.
All we've seen at the hearings have been our folks and a couple of local folks, Boston, BZ, or 25 or 10. So I don't know if whatever the new Court TV looks like or is going to be there, or because now they're with Law and Crime, so whoever's doing it.
Right, and they're going to have a trial channel. Law and Crime is already, if you notice their logo, they've already switched to say there's a channel that says Law and Crime Trial Channel.
Right, which they started a long time ago, but it was kind of the cast off. It wasn't their main channel. So Court TV is going to maintain its own brand, which is smart. So I don't know. We'll see. That may be the first trial that will test their new operation.
Right.
So one way or the other, it's going to be streamed, and I will put in, as we have before, just to make sure we're covered.
Right.
I fully expect it will be
like you did yesterday.
Yeah. And I don't want to. I'm trying to avoid a situation where everybody gets there and nobody is put in for it, and then everybody loses. So. Okay.
And no one knows how to put the microphone up on at least on the counsel table so that it gets the counsel and the judge.
Well, here's what happened last time. We did that, but the guy there from, I believe it was Channel 10, each of these courtrooms, some better than others, are wired with their microphones and then little teeny speakers, especially along the front of the jury box. Okay. The theory being, if somebody's really soft-spoken, it'll be, these speakers are, I know these days you can have a speaker this big and it'll boom you out of the room. But I can't hear anything coming from those little speakers that I can't hear just from somebody talking in the room. So this guy put his little microphone by that little teeny speaker. I don't know what he got, but it seems to me that was kind of a lazy way to do it. And I don't like to count on that kind of technology. If I can put the microphone as near to the speaker as possible, that's kind of what I want to do. So, and we can't mic the whole courtroom. We can't put one on the judge and one on.
That's
so
what
we
want
put one.
To do, right?
Yeah, we'd love to. If
can.
we record TV, or that was our goal, that was our thing, to be a streaming trial channel. We're not. But then, we can at least put one on the counsel table to get those voices, which is what we've done the last couple of times. So I'm curious to see how that plays out. Okay.
Well, you have a talking dog behind you.
This dog wants out
like,
so badly. Can I leave you for
I
a second?
think I think you
do
should
that?
leave, and I think that Domino should be.
I shall read.
Yeah, Domino should be the definite important thing. Especially when we try to do an animal segment on this show, regard to animals' rights, cute things regarding animals. The last thing we want is Domino, the dog, being uncomfortable. Now, the funny thing is that many of you complain sometimes when our dog takes precedence, like barking to protect us. But we don't, because this is the nature of what we do. We show you our lives. We stream within our lives, and you like it or dislike it. You get to learn about why we love our animals, how we love our animals. Even Missy Mayhem, when she's here, sometimes we'll have Pixie. You don't see her, but she has Pixie the parrot on her shoulder when she is producing. So it's we don't mind. I mean, we'd love to have Pixie the parrot on as a regular, shall we say, commentator, right? Just like we have Tubi on. So I'm telling everybody, I don't know if you heard about Pixie the parrot and how we love our animals, and that is so important for you to go let Domino out, because we intersperse our rip and read usually with an animal segment, as we did on Wednesday, as we did on Tuesday, as we did on Monday, and as we did today.
Animals. Yeah, and I've left the door unlatched because there's a good chance he'll just want to come back in and he'll just bulldoze the door down. Okay, so anyway, again, we're looking at the Commonwealth's requested questions for voir dire of the jury coming up at the Kelsey Fitzsimmons case. 16, will you have any difficulty obeying my instructions to avoid all reference to this case outside this courtroom, television, print, social media, etc.?
That's kind of like anybody who wants to be on the jury is going to say, no, I have no problem. Any stealth juror is going to say,
of course. And there's actually, I read this somewhere, there's actually a movement that is trying to teach people how to get on a jury.
Really?
Yeah, and how to minimize the things that would get them kicked off, act bored, act annoyed, during the process.
Right.
It's amazing. I'm not sure to what end these folks want to do this. They have an agenda, but they're saying to get on the jury, you need to do these certain things, and then I guess whatever your agenda is, you can carry it out once you fool people into thinking you're without agenda.
Wow.
Yeah, that's scary.
So this is Marina Moriarty.
Yeah, Marina Moriarty.
All right, as pop quiz. Who was the
Sherlock
villain?
Holmes?
Oh, you see, you read my mind. The villain that I didn't even get to, in Arthur Conan Doyle's main character is Sherlock Holmes and Moriarty. Everything to Moriarty.
Moriarty. Okay, so that's with the Commonwealth. I mean, nothing. There were a couple about the guns, and postpartum was obviously important.
Right, and postpartum psychosis versus depression is also important, because people, what Justin and the Commonwealth are going to say if they get to the issue of, if the restraining order gets in, because they're trying to keep it out, is that he believed that she was going to harm the child. She didn't have postpartum psychosis, and that's people are very confused about that. I think especially men and many women. It's postpartum depression is a very common thing. I mean, so many percentage of women get postpartum depression after they give birth. They're depressed, and she saw treatment from it. Postpartum psychosis is what the woman in Texas had, Andrea Yates, who killed her 5 kids. That was different.
Oh yeah. Crazy.
So it's important to educate this jury also when you're picking them, unless you don't want them educated. I don't think the prosecution would want them educated. I think the prosecution wants them to think that she's Andrea Yates. I mean, that's what I think.
So if we look now at the defendant's request, they made it part of their motions in limine. They did all the motions up top, and then they put this at the bottom, and part of their omnibus motion. Voir dire, that the court allow the following and related attorney-conducted voir dire questions along with appropriate follow-up questions as follows. Have you ever had any involvement with domestic or other restraining orders? I think that's good. Have you ever had any involvement with contested child custody matters? There may be references to a suicide attempt. Is there anything about that topic that would make it difficult for you to sit as a juror on the case? Okay. Might be triggering for some people.
And you're going to find a lot of people are going to answer yes. Really fascinating.
You know, they had a family member, themselves, and who knows. Is any member of your family or a close personal friend employed or retired from serving as a police officer or other law enforcement officer? Okay. How about anybody in the fire department? Should they be asking about the fire department?
Maybe, right. That's probably a situation. I remember when I went down to Tennessee to pick a jury in the Paul House case on the retrial after, and then he was declared innocent. He ended up being, it was an innocence case and a federal defender's case that went to the Supreme Court and got reversed. But when I went out to pick a jury, we had this jury questionnaire and all, and members of the jury came in, they were cops, they came in with their full uniforms and all sorts of stuff. And then be like, the court clerk would be, hi, Jacob, hi, Jake, you know, oh, hi, Louisa, you know. Everybody was related to each other. It was a small town. They knew each other. And they just went to court, you know, in their full uniform because they were leaving work to come to do jury selection. It was a riot. I have to say, it was the funniest thing I've ever experienced. I'm glad I didn't have to try the case.
Oh my, yeah, that's I mean, we hear in cases like the Karen Reed case where the court didn't want any witnesses who were officers to wear their uniforms when they were testifying.
Right.
I can't imagine sitting in the jury veneer, which is the panel from which they pick the jury. They're in their uniforms.
They're all in their uniforms, the big guns and they're big guys. Oh, he's talking. I
had to yell at Domino to take a breather. I don't. He's usually pretty calm, and I don't know what's going on. Did Timmy fall down the well?
That's what I always say. That's a Lassie, by the way. Everybody doesn't know the old say Lassie. Whenever
what is it, girl? What happened? Is there a fire at the mill?
Yeah. And did Timmy fall down the well? Timmy was the young child, and that's what I was saying when Toomey's barking. Did Timmy fall down the well?
Okay, let's see. Custody matters. I think that's important. Suicide attempt. Yes. Law enforcement. I do think, should be any. I think you might even go further, government entities or agencies. Right. Are you now, or were you ever a member of the law enforcement agency, public or private, in civilian or in military life, whether paid or voluntary? So that does stretch it a little bit, but I think you might want to touch on public service like EMTs and firemen.
And also court employees. I don't know if it's down here. I don't remember seeing it. You really have to talk about whether you have been a court employee or involved in the courts. I mean, we had that inspector. We ended up with the person who was involved in the court. She knew all the prosecutors, and we actually left her on for various reasons, which I won't discuss. And she ended up being one of our not guilties, but we left her on. But you want to know, you need to know, what the job is, because you'd be surprised that, well, I think cops are not good to leave on in a case, that sometimes court employees, they have a different view of all the people they've been in.
Yeah, just ask Becky the clerk.
Right.
and the Alec Murdoch case. Yikes.
Yikes, right.
Yeah, for those who may not remember, there may be a new trial coming. Who knows? Those issues are still hanging out there. Mm-hmm. But she was very concerned about the jury coming to the right decision. I'll put it that way.
Yeah.
And I think if that's fleshed out in the, Robert Harpootlian, yeah,
Dick Harpootlian. Dick
yeah,
Harpootlian.
Dick Harpootlian, thank you,
Yeah.
the primary attorney for Alec Murdaugh. I think he's got some decent arguments there to retry the case.
We all knew when the judge questioned, that was, I said at the time we were at Long Crime, it was ridiculous questioning of the jury. Just ridiculous questioning of the jury.
Yeah. They called him in and asked, "Did she influence you?" No.
No.
Okay. Thanks for stopping by. Okay. Okay. Let's see. When you learn that the police have arrested or charged a person for a crime, what do you say to yourself concerning the likelihood that the person, in fact, is guilty of the crime? Okay. So just looking for people who are predisposed to thinking, you're sitting there at the defense table, you done something wrong.
You're right. Why are you sitting there?
Otherwise, you wouldn't be there.
Mhm.
I wonder if in Massachusetts and in that little enclave area outside of Boston, whether it be North Andover, Lawrence, and this will be in Lawrence, or the Triangle of Terror, Dedham, Stoughton, Canton, if people who live in that area have been so inundated with stories about the Karen Reed case, about the Sandra Birchmore case, about the Brian Wall, all of these cases, I wonder if people have started to look differently at people sitting there at the defense table.
Well, I think it depends on the crime charge. I think, to be honest with you, if you're looking at Brian Walsh, right?
Yeah, Brian Walsh, the problem.
I mean, let's face it, you and I, we're defense attorneys, right?
We'd
be problem, like, yeah, I think he's guilty.
The problem with that case was such horrible investigation. It tempted to free him because they did things so poorly that a lot of the evidence that ultimately convicted him might have been excluded. So that uproar was a different uproar, but still, it's all about the authorities not doing their jobs properly. In that particular case, maybe they did it so badly, a guy we think is guilty is going to get off, as opposed to people who we thought were innocent might be convicted. Either way, I just think it's a different way to look at it. Oh, the dog's back. Oh, hey, thanks for joining.
In what is the person who disappears? What's the horror flick? He disappears.
The Invisible Man.
The Invisible Man. There we go. Yeah, the Invisible Man, where the door opens and the Invisible Man is coming in, even though you don't see him. That just happened to you.
That was Domino was crawling in low, so the door.
Right, the door started open. You didn't see Domino until he got on the sofa.
Look at I don't know what his deal is. What's the deal? You're being a little weird.
We're talking about the fire department in this case, and there
you're right.
You have
maybe he's sensitive. He's triggered.
He's triggered
by the alien. Maybe, I don't know. It could be. That could be. Okay. Let's see. Do you believe? Did I skip this? No. Do you believe a person would not be arrested or charged unless they had done something wrong? So kind of a follow-up to F, and that's G. H, similar. Do you believe if someone is arrested, indicted, or charged with a crime, then he or she must therefore be guilty of some crime? Do you believe that a criminal defendant should testify at his trial in order to help establish his innocence?
Very good question.
It is. Yeah. If people think that, hey, if you didn't do it, why aren't you telling us you didn't do it?
Right.
I think in this case, I haven't got any insight other than my own experience. I think she will testify because it has such unique elements that are very different than a self-defense case or a very straight murder, which is not a murder case. I don't know. I think it's better than 50-50 that she's going to testify.
Yeah, I think there's a chance she could do it. It depends. This case really depends on how the prosecution's case go in. This is a decision, you cannot make. We all tell everybody we don't make a decision whether our client's going to testify or not in any case, because we want to keep the prosecution on their toes. But in this case, you have to have a prep, but it really is one that you have to make after, because maybe they don't make out the case. Maybe there's so many problems in Noonan's testimony that it doesn't get made out. Remember, this went. Hi, Domino. This case, remember, let's talk about the status. This case went to the grand jury with different charges. Oh, you have help. Lisa's home. Yeah. went to the grand jury with different charges, right? She is being charged with what, Michael Bryant? This is a test quiz.
Yeah, assault with, well, basically assault with a deadly weapon. I think
Right.
they call it a dangerous weapon.
A dangerous weapon.
Yeah.
She was charged with, second quiz,
Oh, what was that again?
she was charged with.
Oh, well, they tried to get her with the intent to murder.
Right, and the grand jury rejected it. So
No bill on that.
clearly, since you can indict a ham sandwich
Mhm.
or a cheese sandwich these days if you're vegetarian, or maybe a lettuce and tomato sandwich if you're vegan, okay? Since you can indict one of those, and she wasn't, there had to be some real serious problems in that grand jury with how they felt about this case.
Yeah,
So
well, I think if you look at just the raw facts as we believe them to be, it is a he said, she said, those damn body-worn cameras they couldn't afford. It sounds like a very spur-of-the-moment struggle scenario. And how you get from that to intending to kill someone, even the grand jury couldn't make that leap.
Right.
So.
Right. And it may be that, even though the police had cleared her to come back to work, maybe we're going to find that, because we haven't heard anything about medical evidence, that she was still suffering from some type of postpartum depression, which would indicate that she could kill herself.
Yeah. Yeah. And we know that the reference to what Noonan said could be interpreted a couple of ways. Don't do it. Kelsey, stop, don't do it. Well, don't do it. Like, don't shoot at me or don't shoot yourself.
Yeah, right. Exactly.
So that testimony is going to be critical, and the
Yeah,
cross-examination.
and I think
of that
there's
testimony.
two versions of that, isn't it? What somebody heard downstairs and what somebody heard upstairs are two different versions. So that could be really
Sure.
interesting too.
Yeah, well, yeah, especially if they contradict one another and don't, if Noonan's statement, he obviously is the one who allegedly uttered the words. If they aren't corroborated by anybody, that's going to make it more difficult. And I think those are the kinds of things you're talking about when the prosecution sits down and rests. How did he come off? How did the alien come off in whatever capacity he's going to appear and testify?
If he just says, let's put it this way, let's do a hypothetical. If he just says she took out the gun and started to lift it, okay, all right, and he says don't do it, thinking but doesn't say that he pointed it out him specifically, I think you rest, you don't call her, because that goes to the fact that she could be lifting it to kill herself.
He said that she actually pulled the trigger and that nothing fired. It was just a click.
Right. I saw that. But that doesn't mean, so where? She pulled it at him, or did she pull it at herself?
Was it in this position? I'm trying to get a better angle. Was this position? Was it this position? Was it at him in that position? Seems to me to justify his returning fire, it better have been pointed at him.
Him, right. Exactly.
But again, we're only going to have her word versus his.
Right.
That's it.
That's it.
So I think if you
and where's the first shot? Where's the first shot? Remember this.
Yeah, we can't find that. Yeah,
we don't know where that first
shot
shot landed, right?
Yeah.
Right.
He missed somehow, either intentionally doing to scare her, or just he's a bad shot. Too much was happening. It wasn't until the second shot was fired that it found its target. But if his testimony comes off so shaky about anything else, then it's going to be less likely the jury's going to believe him on that very important issue about where was she pointing the gun when you said it was attempted to be fired.
Right.
And then the jury, it's a gutsy thing. You're in that situation. You've seen the case, prosecution. It was, the nuts and bolts were there, but it's not very strong. I'm trying to read the jury. Do we have our client testify or not?
Right. And the problem I have with that is that whenever you have a client testify, you have to in a self-defense case. It's no issue. Right? But whenever you have a client testify, and I keep preaching this over and over when I teach, the case only comes down to what the client says. Everything else you did in cross-examination, everything else you did in good, everything
so well
goes by the wayside.
Yes.
It goes by the wayside. It only comes down to the client. And if the client makes one misstep or one thing that turns a juror off, you're screwed. Okay. So that's it's a very difficult decision.
Yeah. And that's the reason most of the time defendant does not testify. This could be the exception, just because the nature of the defendant and the allegations being made. Okay, what else we got here? Oh, Jay. We're on Jay now. Does the fact that Ms. Fitzsimmons is sitting here today facing charges make you think wait a minute, what's going on here? Must have done something wrong. Maybe we got a whole new issue raising its head
there's a
here.
she. You want to call Tim, tell him that maybe there's a typo?
Tim, hold it. You need to buy an S. Okay. Do you belong to or support organizations or groups, religious or otherwise, whose philosophy or beliefs would make it difficult for you to decide the issues in a criminal case? Okay. Fair. Again, more of a boilerplate question.
Right.
Do you understand the proposition that if you view two competing versions of the facts of the case, he said, she said, to be equally likely, that is not proof? That's a very good question in this case, especially. Right. That is not beyond a. So if you're sitting there going, and that's what I call the I don't know what the hell happened test. Remember, Karen Reed, perfect example. All the testimony, all the expertise, it's all in, it's all done. I still don't know what the hell happened. Well, that's not guilty.
Yeah. Well, although I do know the state didn't prove beyond any reasonable doubt that the car ever hit him. So that's the problem, even from their own side. So there we go with that. The Karen Reed had that additional thing. But yeah, and this really comes from a jury charge, because the judge is going to charge the jury that if you find the facts are equipoise, that you don't know that you can take you have to look at the facts in the best viewpoint possible to be not guilty, right? And once you look at that, if you can't find beyond a reasonable doubt, goodbye, so long, farewell. So that's coming from the jury charge.
Yeah, so they'll hear that a number of times in different ways. The defendant further moves pursuant to General Law 234, Section 28, Mass Rules of Criminal Procedure, and Flabat and Whiting and Young, all of those things. Voir dire required in case involving interracial murder on request of defendant. Just referencing the Young case. These questions be asked by counsel during an individual voir dire examination of each potential juror. Otherwise, possible personal issues or community attitudes toward the offense with which she is charged may cause a decision to make in whole or in part upon issues extraneous to the case. I think, to your point earlier, it could taint those that are sitting there waiting. How would I answer that question? How does whatever that person just said affect what I would be saying?
And also it goes to the fact that when we did it in some of the cases, normally about the suicide would be on a jury questionnaire, and those wouldn't be access to the public, those answers to those questions, because some people don't want to talk about it. Maybe they had a cousin who died by suicide. Maybe they had that's all, or maybe they had, and this is especially important, like in drug cases. Okay, does anyone or close to have a drug issue, have been in jail for drugs, drug treatment, whatever? People don't want to admit sometimes that that's the case, right? They'll admit it to the judge, but they don't want to. Oh yeah, I've got X, Y, and Z who are drug addicts and they've been in jail for drug distribution. They don't want to admit that, and they'll try to conceal it, and it's not really concealed, but you have to put them in a private place so they can feel comfortable.
Yeah, they're not going to be willing to share. So. Let's see. And finally, that the court exclude certain prejudicial and inadmissible references as follows: that the defendant resigned from the police force. This is kind of motion in limine buried into voir dire questions, right? That the residence of or defendant is known to us as a repeat offender or repeat location of police visits, that the defendant fled a particular location. Any attempted characterizations or opinions about the defendant's testimony or state of mind, that the defendant was a target of an investigation, and any other interpretive purported opinion testimony about what was said or intended by another person and related references.
Right. This is an eliminating motion, isn't it? It really is.
It really is. Yeah.
So the prosecution can't sneak these things in terms of a jury voir dire, which can happen.
Oh, well, yeah. And then, because then it's the cat's out of the bag.
Right.
Especially if they've asked it to a group and not just to one person. And that's a defendant respectfully requests the court enter the foregoing rulings and grant such other relief as it deems proper. So Martha Coakley, Tim Bradle, signing away.
Mm-hmm.
So
lead counsel signing away there, and you have, I guess, an assistant counsel, second chair, signing away on the prosecution's voir dire questions. which again, in my opinion, were basically code copied. Maybe with the
Yeah, those
additional
were definitely cut and pasters,
postpartum, whatever.
except for the postpartum. They got
Postpartum,
into
right.
much more specific, much more on point in the defense. And if you think about it, it should be really. I mean, the defendant's the one on trial. Yes, we know the burden of proof is what it is, but the defendant is the one needing to protect every single element of the case that's being brought against him or
And
her.
of course, the real thing is what's the scope of what the judge is going to allow in on testimony? Are they going to allow in the fact of the reasons for Justin the alien's or Alain, as the court asked, and I only say Justin the alien because when you were there a couple of weeks ago, the court referred to him as Justin the alien, or Justin Alien. Obviously, either our broadcast got through or whatever, and then asked.
Or I'm just a normal guy who's made
Yeah.
the same mistake as the judge.
Yeah.
I don't even know really how to pronounce it still. I've gotten
Alain.
lazy. Is Alain. It's not as difficult as it looks when you read it.
When you read it, right?
It's a lot of vowels.
Right. So what do? Do you let if you're going to let in, you can't let in the hearsay of the affidavit, or can you? Can you say this is why the police were there because it's not for the truth of the matter, but they had an order, a restraining order that they had to execute? I mean, I guess a court could do that and say, therefore, it doesn't matter what the truth of the matter is. They had a restraining order. They went in to execute this restraining order, and this is what they knew. We're not saying it's for the truth, Your Honor, ladies and gentlemen.
It seems to me that that's even beyond hearsay. That's so prejudicial.
Yeah, I agree, but it could happen. I could see a judge. I could see a judge in Massachusetts doing it and saying, therefore, Justin does not have to testify. The only thing that matters is what they were there to do, and this is what happened when they got there to execute the warrant. That's it. Boom. Well, we're not telling you it's true or not true, but they're going to say it is prejudicial because they're going to test to the fact that he got the restraining order because she was a danger to herself or her child, right? And therefore, she has to be by extension a danger to Officer Noonan, who was her partner, right? I notice that's not mentioned in any of that.
No, and I'm sure that'll come up. You know and remember the important case they had together, where it was a mother and infant or small child murder suicide, as I recall, right?
And they had together when she was pregnant.
They rolled on that and experienced that together. So you would think it would make Noonan so much more respectful, sensitive when asked to separate Kelsey Fitzsimmons from her son on that day in June.
Out of the blue. I mean, when you think about this case, out of the blue, here she is. She's so happy, right? She moves in with she thinks is the love of her life. Big mistake. I mean, I think that shows a lack of judgment on her part, obviously. But you don't ever know what goes on in a relationship. There, he's paying, according to him, half the mortgage. I guess his aunt gives him a $5,000 present when the baby's born in January or there around, which he then takes back from her on the basis that it was his money. Yeah, obviously already long spent, right? They get into some kind of tiff, whatever the weekend before, whatever that is, whatever the tiff is. And then he goes and he gets a restraining order without telling her that there's an issue, leaving her in a park. She's happy. She's got a baby. She went to counseling for postpartum depression. She's now about to go back to the police force. She got the approval. She's got a child. She's going back to the police force. She's getting married in October. Life is all of a sudden really good. And then it's all of a sudden taken away from her by Justin's actions without telling her.
And no real indication in that 1 week between what allegedly happened in Maine at the bachelor party and what happened on June 30th. It just out of the blue, sandbag.
Out of the blue, right. Just terrible.
And that's not really the adult way to handle it, but don't get me started.
And you gotta wonder whether or not there's going to be evidence about how well the baby was cared for and treated from the. I mean, I don't know whether I didn't see a pediatrician or doctor in there, but there's no indication that the baby was not treated well by Kelsey.
No, the only medical expert I saw was Zeisel, which I think is a mental health professional.
Yeah,
that was on the list anyway. So I don't know. Because there's so much of that backstory that has to come in, because you can't get to the day of the incident without knowing what led up to it, which includes the party a week earlier, whatever the rift was, the affidavit that's being crafted while she's waiting at the park for him, and then for
3
him to show up.
hours.
3 hours, and then I sure hope we get into the procedure for whether or not the significant other who brings the request to remove the child from the mother is then brought to the scene 10 minutes after the fact. So much of that is reinforced by all this extraneous stuff we've heard now about his reaching out to the cops. We have that letter. I don't know if we have time to get into it or not.
Yeah, I think we have a few
a little
minutes.
bit of time.
We have about 7 minutes left.
All of that, stinks of favoritism.
Right.
That he is taking advantage of as a
One of the good
fireman.
boys. One of the good old boys.
He's not a cop, he's a fireman, but we're in the brotherhood,
And remember, Kelsey had a suit against the chief of North Andover Police Department, which miraculously went away when she was going to go back to work. Right. She was miraculously withdrawn as part of
Let's look at some of this. Is from the phone log. This took place the day of the break-in, okay, which was July 3rd. Take a look at the time on this. 10:30. You can barely see the stamp at the top, but as it carries on down, it's 10:31 a.m., right? The break-in was at about 9:30. So keep that in mind. This is after the fact, okay? Why do you call after the fact? I'd say you do that to cover your ass. Speaker says, Northern Police and Fire, this call is recorded. And then, hi, this is Justin. You want to be somebody? You want to roll in this? You want to be the?
Yeah. Well, you want
Justin.
Wait, there's 4 speakers here.
Yeah, it's funny how they keep doing that. I'm not quite sure how. These
transcript
problems.
Why don't I start? Speaker 1, North Police and Fire. This call is recorded.
This is Justin Land. I'm on the North Fire Department. I'm off duty right now. I do need to speak with DOIC. I'm guessing that's somebody in charge.
Speaker 1, yes, sir. Hold on 1 second, please.
And then it's whoever comes on. You're the new person now.
Hey, is this Justin?
Yes, this is.
Hey, it's Katie. How are you? I mean, that's a silly question, but I digress. I do care.
No. I'm doing as well.
Thinking about you right now. Yeah. So what can I do for you, Justin? What's that?
I needed to discuss my options of retrieving all my belongings from Phillips Brooks. Okay, now, once again, I have the drama of this not being on one document. Okay. I gotta get a better staff. I don't know what to tell you. Okay, so now I need to get document number 2, which generally comes after number 1. Let's see if it does. There we go. Okay. And
thinking about you right now. Yeah. So what can I do for you, Justin? What?
Wait a second. Now I'm behind you. Hold on a second.
You're here.
I needed to discuss my options. Did I already say that?
That's okay. We're repeating it.
Okay. My belongings from Phillips Brooks.
Yeah. Oh, gotcha. Well, it's your house, so I'm assuming that you can make whatever arrangements if you just want us to let. Because let's just say if this were, a scenario we deal with in any other case, a restraining order, there's nothing barring you from returning to your own property except for your own safety. So we don't have any jurisdiction and we don't even navigate about the mutual property. So when we get restraining orders, people have to, commonly the defendant would ask to. It's different in this case. Because you may be in stow, from what I understand, but any property that's in there in between you and Kelsey and those civil courts, it doesn't have anything to do with us. We have no jurisdiction to say what can't be removed, what can be removed.
So am I able to go to the house with a bunch of fire buddies and remove my belongings?
I just know, yes. We have no jurisdiction on that. I have to continue. We have no jurisdiction on that. Have no jurisdiction on that.
So I understand you have no jurisdiction
on that. You cut me off. Okay, so there was something else that I didn't finish there, but I'm in no communication with your family.
Oh, is that?
You cut me off.
I cut you off.
Whatsoever. Go ahead.
Okay.
Yeah.
So then I think you're still 3.
Yeah. Yeah.
So
Do you
I
know?
say, Justin says, no, I have no communication. But no, why would that be both speaker 3 and 4? Sounds like the
Yeah,
same
I don't
person.
know. It doesn't make any sense.
Yeah.
All right.
Okay.
So I'm going back to speaker 3. Yeah. Do you know if they're at the house at all? That would be my only thing. If you wanted to, I don't know them. You go. If you feel like they're there, I mean, it's your house. So truly, you can go in there anytime you please. And let's just say hypothetically, they were there and they all get bent out of shape about that. What you could do is just call us for us to explain that to them.
So my only concern would be, I know they're blaming me for a lot of this.
Situation. Yeah. I get it. Yep.
They are well, yeah, the potential retaliation of any of the sorts. Yeah.
So you can play it however you want it to play it. I'm going to leave that up to you. One option would be to shoot them a text or anything like so. Just
Oh, sorry. Oh, we're hanging again. So wait a second. I'm sorry about that. I'm trying to queue up the second one, and the third one was not done yet. Hold on a second. Let's go back to number 3, and I'll let you finish that before I grab the other one. Where'd you go, you little rat? So there you are. Okay, back to number 3 to finish it.
you can play it however you want it to play. I'm going to leave that up to you. One option would be to shoot him a text or anything like, just so you know, I'm going back to the house to pick up some belongings. They
would they would they
would you could
would they, where'd I go now?
No, you would continue would say then to say no, absolutely not.
Okay. Well, I'm pretty sure they would show
up. Yeah. Okay. So what you may want to do is just go do what you got to do. I can't keep you from there, nor would I want to. It's your house as well. It's your property. So it's
technically the deed is in her name. Sure.
Sure, but you're obviously
residents of the house.
Yes, you have legal standing in there as far as the civil clerks, civil courts are concerned. You have keys, you have access. I know you live there. We know you live there. We're not going to stand in your way from collecting your property if you go there and do your thing. And just if you get there and someone's there, we can, before you even go into the house, you could call us and, meet us over at the school parking lot and be like, they're there right now. Can you send someone by to keep the peace? And we'd be happy to do that for you. We do that all the time, okay? Especially if the roles are reversed. If you had been asked to leave the house, we do this all the time. The person who has resided there has a.
Oh, it's gone. Oh, sorry. There we go. Sorry. Oh, I'll hold it up.
Has a legal right to grab things. Okay.
Okay. And scene. That's all we've got. There was some pleasant.
So Katie is telling him, "Hey, I know you live there, you buddy here. You have a legal right to grab things." He tells him, even though the deed's in her name. Don't worry about it.
Apparently, it's Attorney Katie. Because she's giving legal advice.
Yeah, he doesn't tell him he doesn't have a key. He doesn't tell him that.
Yeah, he does admit that she's on the deed, but he says he lives there. He lives there. That's just a lie.
Right.
Because he hadn't been there for the prior week. Part of the whole dust-up.
It's a whole issue, right?
And, of course, he swore to that. And now we read the documents earlier this week where he says, no, I've never sworn that I wasn't living there. Well, then the probate and family court, to get what he wanted from them, he said, no, I don't live there. I live in Stowe.
Right. And that was the issue when we went to the family court. Remember, like, where do you live? Where does he live?
Yes. And to talk about that, one of these days, I'm going to draw the map. But you'll recall, he told the court that he was 22 miles away from North Andover, and that North Andover has a rule about how far outside of their firehouse jurisdiction you can live, and it's 20 miles, which to me sounds like a lot. The reason I say that is because remember one of his buddies who's now with, say it with me, Haverhill, who's with the Haverhill, that's only 7 miles north of North Andover. Mm-hmm. So you can live in a 20-mile circumference and still be That seems to me that's liberal. And he told the court, hey, I got dispensation to do an extra 2 miles. I'm 22. He's like 30 miles outside of North Andover, at least. And I just want to put together a map so I'm look more formal and just put a 20-mile circumference around it and then show you where he lives. It is so far outside that 20 or even 22-mile limit. It's just another fabrication.
Yep. Yeah, so we'll have to see. I mean, if he gets on the stand, there's going to be a lot going on.
Oh my gosh!
But the prosecution may put him on the stand on the basis that the police, Katie, his friend Katie, said, go ahead. We do it all the time. But what they do is they do when there's a restraining order and someone calls and says there's a restraining order against me. I need the police, and there's a court order that says you get the police to accompany you, give notice to your other side, and you can go pick up your things. That's what happens. Because somebody's got a restraining who can't come back to get the things. So the court then gives them dispensation, but says you got to get the police involved for protection, but you can go back upon notice to the owner, the person you're restrained against, so that there's no issue. That's not this case.
No, and we know now it's starting to come out that the alien's mom, Lisa, has made calls herself to the police department asking for special favors because they're so afraid of Kelsey Fitzsimmons, the evil demon.
Yeah,
and her family.
Yeah, so afraid of them. She was fighting for her life in the hospital, but she's afraid of them and the family. Wow, you're so afraid that you're willing to go back and break into a house and rip off the camera equipment. That's really afraid. I guess that's why you bring mafia muscle and you bring three of your
buddies.
Buddies.
Hey,
buddies.
Those guys are, I don't know if they're just stupid, overly loyal.
No, they're part of the good old boy network. This is the good old boy network. This is not the good old girl network. This is the good old boy network. Even the mom is in the good old boy network. Okay.
Yeah. Well, we're seeing a lot in Massachusetts of this small town attitude. That the rules don't apply. We run the show. We'll do what the hell we want to do. And some of those roosters are coming home to roost. Is that what happens? The chickens are coming home to roost. Yeah.
Well, this is an interesting way to end the week on Fashion Friday. We started with Kylie Jenner, and now we end with Katie and Mommy, as you point, Mommy Dearest.
Mommy Dearest. Yes.
With Justin Alien. And who's the victim here? Let's not forget there's a child who hasn't seen her mother.
Barely
and there's
a year
grandparents old. Who are that the other grandparents, Alien's grandparents, are refusing to allow them to see their grandchild. I mean, that to me in of itself, I don't need to know anymore.
Yep, that's generational evil. They seem to have passed it down to their kid. All right, then. Big weekend plans? Anything exciting? What's happening?
No, we're going to go later on to the cabin. Just check it out for a day. Be back probably just after an overnight. As you know, last week we had a couple of functions to go to supporting our local community up in the Barryville Greater Chamber of Commerce for kids who are going to school. So I call them kids, but they're scholarships for young people going to school. And, I think it's important in any community when we support them in a good way, not in a bad way.
Yeah, good for you. I'm going to lay low. Most of the snow is going to be gone at the cabin, I'll bet you.
Yeah, but it's coming back on Sunday, freezing rain. And it's St. Patrick's Day parade. It's going to be really cold. And but the last of the false winter is going to be gone by next Thursday.
Yeah, it's been 3 or 4 great days, so I can't complain. The other day I almost said, boy, it's so warm. But I stopped myself. I didn't want to complain. All right, folks. Hey, have a great weekend. We appreciate you joining us here. What should everybody do?
Don't forget to subscribe. Hit that subscribe button. Give you a chance. Like, share, notify, and hype.
And this is Justice Served TV. So please have a great weekend and try to do the right thing.
Discuss